Okay, Jefferson County Court of Law number 2 is back in session. Court is in session on today's date of February 3rd, 2025. Court is in session on its jury trial docket. And we have several cases set. We have a specially set case set for number 1. That case is clause number 23CCCR 0390. Case of style of state of Texas versus Denair High. Mr. High is present in court with his attorney William Wilkerson. And state is present in court, Assistant District Attorney Haley Simmons. Ms. Simmons, Mr. Wilkerson.
Yes, Your Honor, I was approaching on the information. There's some surplusage of language here that the state intends to abandon. I do have the strike read right here. I don't know if you need a copy of it in terms of the language we seek to abandon.
Okay, you saying that there's some surpluses of language.
Yes, Your Honor. The state's not making any amendment on the indictment. We are adding language within it.
Oh, well, let's do this here. I don't think you have to have a good defense. Do you have any objections?
To the striking of surplusage? No, Your Honor.
Okay.
Did you see?
Yes.
air, but by striking Victoria Senegal's face, and
Oh, bye-bye.
I have the cross out right here if you need to see it, Your Honor.
Yeah.
Oh, yeah. I don't know.
Actually, actually, you're making a change. Cause you went from face to now you're just going to grab it. I mean, it's played in the, conjunctive, you could prove it in the disjunctive. You just took out face.
Your Honor, we're abandoning that language entirely.
About striking.
The
No,
by striking
did you read
Victoria's-
what she had? Did you see that, what I just looked at?
He has, Your Honor.
Yes,
She struck through by striking Victoria Senegal's face.
right. So it will read by grabbing her neck with his hands.
Yeah,
The question then becomes, obviously, does it then drop to simple assault to class C misdemeanor because there's no allegation of pain in the information? But I was gonna wait until we dealt with the jury before I brought that up, Your Honor.
caused bodily injury.
Bodily injury is sufficient for pain.
That's what it says. Just by, I mean, you're talking about an offensive touching, that's. It doesn't say, it. In fact, Class C is not a Class C assault is not a lesser included assault of a Class A assault.
In any event, Your Honor, we have no objection to the state's striking of the surpluses of language.
Okay. So you're gonna take out by striking Victoria's face and
Yes, Your Honor, by
And it's
striking
got-
Victoria Senegal's face and.
you're gonna say by grabbing her by the neck with his hands.
That is correct, Your Honor.
Okay. Okay.
Did you need to make a copy of this? Would you like me
Yeah,
to?
we're gonna have to put that in the, goes to the means and the manner. Yeah, it'll be okay.
That's all
You
that
don't
they
have
to
anything else?
unfortunately. No, Your Honor.
No, Your Honor.
Okay, so, I'm gonna need that one when we, like, she's gonna read it to the jury during
That's
the,
tomorrow when we begin.
Right. make sure we have it. I don't know if you have it on your, yeah, okay.
Judge, I do want to make the court aware, and I don't see this being an issue. I really believe that we might finish tomorrow afternoon. If not, then Wednesday afternoon. But on Thursday afternoon, I have a Houston doctor's appointment to refill my pump that I won't be able to miss.
Oh, okay, well, today, Monday, Tuesday, yeah. Okay.
And again, I don't see it being an issue, but I did want to go ahead and make the court aware.
Okay, we'll, thanks for making us aware, and, if we don't finish, we'll be able to work around that, schedule. Okay,
Yes, sure. Yeah, I really think we'll be very fine.
so. Miss, all of those people that's sitting on those rows, they need to be sitting on the last two rows. Okay, everyone in the gallery, please sit on the last two rows. The jury's gonna come in. Miss Mosby, you need those cameras Jefferson County Court, law number 2 is back in session. The court is in session and calls number M327087. Case is style of state of Texas versus Brian Schenkel. Mr. Schenkel, is that your full name?
Yes, sir.
Mr. Schenkel, would you please raise your right hand? Schenkel, do you swear affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Mr. Schenkel, you may put your hand down. How are you doing, Mr. Schenkel? Excuse me, Mr. Schenkel, you represent the case by your attorney, Bryce Kimler. Attorney Kimler, how are you doing?
Mr. Guy, criminal district court, pretty good here.
Okay, and Mr. Kimler, do you waive a record in Mr. Schenkel's case?
So
Mr. Schenkel, I have before me on my computer a document that is titled Information. This information was filed by the Jefferson County District Attorney's Office. In this information, it alleges that you, Brian Schenkel, on or about April 25th of 2020, while you were in Jefferson County, Texas, that you committed the Class A misdemeanor offense of resisting arrest, detention. Now, Mr. Schenkel, did I swear you in? Now, Mr. Schenkel,
Did you say resisting?
excuse me, evading arrest, detention. I said resisting, excuse me. Class A misdemeanor of evading arrest, detention. Mr. Schenkel, do you understand what you have been charged with? And to this charge, Mr. Schenkel, how do you plead? Guilty, not guilty, or no contest?
Guilty.
Guilty? Now, are you pleading guilty freely and voluntarily?
Different.
And are you pleading guilty because you are guilty? Mr. Schenkel, I also have before me on my tablet a document that is titled Misdemeanor Plea Admonishment. This document is also labeled as State's Exhibit Number 1. Do you recognize this document? On page 2 of this same document, there's a set of initials BS on the line next to a box that's checked guilty. Did you place your initials on this document? On page 3 of the same document, there's a signature above the line that is titled defendant. Is this your signature? And on the next document that's titled trial court certification of defendant's right of appeal, do you recognize this document? And is this your signature on the line that's titled defendant? At the top of this document, there are 2 boxes checked. The first box that's checked states that this is a plea bargain case and you have no right of appeal. Do you understand that statement? Second box that's checked states that you're waiving your right to an appeal, which means you're giving up your right to an appeal. Do you understand that statement? Mr. Schenkel, I also have another document. This document is on paper. The document is titled Discovery Certification. Now, Mr. Schenkel, do you recognize this document? And is this your signature on the line that's titled defendant? Now, Mr. Schenkel, before you signed and initial all of the documents that I just showed you, did your attorney go over these documents with you? And did you understand everything in these documents? And is everything in these documents true and correct to the best of your knowledge? Mr. Schenkel, are you a citizen of the United States?
State of Thursday.
Any objection?
No,
No objection. State's Exhibit Number 1 will be admitted. Mr. Kimberly, you advised and counseled Mr. Schenkel. Is there any evidence that he is currently mentally incompetent to stand trial?
there's none.
And Mr. Schenkel, your attorney, Mr. Kimberly, has advised and counseled you. Are you satisfied with his representation? Has he provided full, effective, and competent legal representation? Mr. Schenkel, I will accept your plea of guilty. I will find that you are mentally competent to stand trial. I would also find that your plea and waivers were freely and voluntarily given. And I will also find that there is sufficient evidence to find you guilty beyond a reasonable doubt. State, do we have a plea bargain agreement?
We do, Your Honor.
What is the agreement?
In exchange for defendant's plea, the state's offering 7 days in the Jefferson County Jail, credit for 7 days, and to tax or retire all court costs.
Mr. Schenkel, the state is offering that you serve 7 days in the Jefferson County Jail, but you will not have to serve any more time in the Jefferson County Jail on this case because you've already served 7 days in the Jefferson County Jail. Therefore, you'll be given credit for the time that you have already served. The court costs in this case, Mr. Schenkel, will be taxed and retired. That just simply means that you will not be required to pay the court costs because the time that you have spent in jail has already paid it off. Therefore, the court costs will be taxed and retired. Mr. Schenkel, do you understand the state's offer? Do you think that the state's offer in your case is fair and just? And do you accept the state's offer? Mr. Schenkel, I'll follow the plea bargain agreement that you have entered into with the state. Mr. Schenkel, please stand on the end of the counter and follow the directions of the bailiff. Once you finish following the directions of the bailiff, you're free to go, and you have a blessed day. And, Ms. Bailey, if you could bring in the panel. Get the panel, jury panel. Oh, let me look at the, I need to see the screen. Okay. Thanks. Mike, okay, you're gonna take that first row right here, walk all the way down to the end, in the second section. Mr. Davis, you're gonna sit next to Mr. Gillett,
Sir.
and Mr. Roy, you're gonna sit next to Mr. Dickens. I mean, Mr. Dickens, you're gonna sit next to Mr. Davis. Y'all can have a seat. Ms. Castillo, you're gonna sit next to Mr. Dickens. And Mr. Hanson, sit next to Ms. Stillo, Ms. Castillo. Mr. Warsig, you're gonna sit next to Mr. Hanson. Okay, Mr. Dabney, you're gonna sit next to Mr. Warsig, right here. And Ms. Patel, just follow Mr. Dabney. And you're gonna sit in that first chair on the end. Right there. And Ross, you're gonna sit next to Mr. right there. Yeah. You're gonna sit next to Mr. Patel, Ms. Patel. Mr. Gordon, you're gonna sit next to Ms. Ross. Ms. Holler, what's that, Howard? Yes, you're gonna sit there. And Ms. Brown sit next to Ms. Howard. Wolford, you're gonna sit next to Miss Brown. Sir, how you pronounce your last name? Barkett. Go all the way down to that second row, all the way down to the end, second section. Ms. Bell, you're gonna sit next to Mr. Barkett. Ms. McDonough, you're gonna go in that second section as a seating between you and Ms. Bell. Ms. Leach, you're gonna sit next to Ms. McDonough. And Masquita, you're gonna sit next to Ms. Leach. Mr. Dahl, need to lower your voice, the court is in session. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law Number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law Number 2. Now, you have been asked to come to court today for a criminal trial. It's a misdemeanor criminal trial. But before we get started, I'd like to welcome each and every one of you to County Court at Law Number 2. And I'd like to thank you for taking time out from your busy schedules to be here this afternoon. You will be examined for inclusion on a jury hearing this criminal case. Our courtroom hours normally vary. The courtroom hours are normally 9 to 5. However, here in County Court at Law Number 2, when we start our docket at 9, we have other dockets going in the morning. And most of the time, it usually lasts till 12, sometimes 1, 2 o'clock. And so we start our cases when we're in a jury trial at 1:30 in the afternoon every day. So whether or not you are selected as a juror today, you are performing a significant service which only free people can perform. If you are selected, in this case, this case will be tried expeditiously, consistent with justice, which require a careful and correct trial. If selected, on this jury unless otherwise you'll be permitted to separate yourselves for recess, for meals, and at night. Now, I have two administrative matters that I must take care of, but right now we'll take care of the first administrative matter. And I need each and every one of you to raise your right hand. And once I finish swearing you in, please say I do. Do each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions, touching your service and qualifications as a juror, so help you God? Okay, you may put your hands down. The law requires that each of you must possess certain qualifications before you may be considered for service as a juror. Also, there are certain excuses and exemptions some of you may wish to claim. First, I would like to determine if you possess the qualifications to serve as a juror in this criminal case. It is very important that you answer these questions truthfully. If you do not, and the lawyers or I discover this fact, after you are seated on a jury, the case could be retried, and you may be held in contempt of court and placed in the Jefferson County Jail for a period up to 180 days and be given a fine up to $500. Now, the way I'm going to ask the question, I will ask a series of questions. I do not want you to answer those questions out aloud. Just simply answer them to yourself. And then once I finish asking the last question, and the last question is anyone disqualified under the law? If you think that you may be disqualified under the law based on the way you answered one or more of these questions, just please let us know by simply raising your right hand. And then once you raise your right hand, we will discuss that matter privately. And when I say privately, what I mean is, first of all, we are airing on YouTube. The YouTube will be muted. This mic will be turned off, and this noise device will be turned on, and you will be asked to come before the bench right here. You'd have to talk into the microphone that is on the bench because the court reporter is dictating everything that's being said, okay? And so when you come up here, if you do not remember, I'll explain it to you again. All right, so again, well, I'm gonna ask a series of questions. I want you to answer those questions to yourself. And at the end, when I ask the last question, is anyone disqualified under the law? If you think you may be disqualified, then you just simply raise your right hand and I'll ask you to come up individually before the bench so we could discuss the matter more privately. So the first question, except for failure to register, are you a qualified voter in Jefferson County and the state of Texas under the Constitution and laws of the state of Texas? Have you ever been convicted of a theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, I always pause at this next question because I need to inform you that this question and these questions that I'm asking, I'm required to ask these questions by law. I'm not trying to pry into your personal affairs. The next question states as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 6 months in a county court well, let me back up. Have you served as a petit juror for 6 days in the preceding 3 months in a county court, or 6 days in the preceding 6 months in a district court? That was the last question. Now, is anyone disqualified under the law? Think you may be disqualified? Simply raise your right hand. Let the record reflect that no one on the panel has raised their hand. So therefore, at this time, all members of the panel are qualified. Now I will proceed to exemptions. If anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions, you may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these exemptions apply to you, but you still desire to be considered as a juror, just remain seated. Now, I will ask these questions in the same manner that I asked the previous questions, and that is, I will ask a series of questions, want you to answer them to yourself, and then when I ask, is there anyone here who would like to claim an exemption? You raise your right hand, and then we would ask you to come before the bench and discuss that matter more privately. First question. Are you over 75 years of age? Do you have legal custody of a child or children under the age of 12, and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance at an institution of higher education? Are you an officer, employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Have you served as a petit juror in the county or in this county during the 3-year period preceding today's date? Are you the primary caretaker of a person who is an invalid, unable to care for himself or herself? And this is the last question. Are you a member of the United States military forces serving active duty and deployed away from Jefferson County, which is your home station, and out of Jefferson County, which is your residence? Is there anyone here who would like to claim one of the exemptions? Let the record reflect that no one on the panel is claiming an exemption. Now I will proceed to excuses. And the way that we'll handle the excuses, I will make 3 statements. I will not ask any questions. And if you think that you would like to claim an excuse, you just simply raise your right hand, and we would ask you to come up before the bench to discuss the matter more privately. Now, the law says that a juror may be excused for observance of a religious holiday upon completing an affidavit, as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties, that is, without the consent of the defense and without the consent of the state. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone on the panel who would like to claim an excuse? Let the record reflect that no one is claiming an excuse. So let the record finally reflect that all members of the jury are qualified, no one is claiming an exemption, and no one is claiming an excuse. State. Are you ready? Defense, are you ready?
Ready, Your Honor.
Okay, you may be seated. Let the record reflect that the time now is 12:21 p.m. on today's date of February 3rd of 2025. The case before us is styled the state of Texas versus Denair High. The defendant and the defendant's counsel and counsel for the state, all members of the panel are present. Now, members of the panel, you have been summoned to this court, as I previously stated, to serve as a prospective juror in a criminal case. The case before us is the state of Texas versus Denair High. Mr. High is sitting at the table before you with the purple shirt on, and he is represented in this case by attorney Marcus Wilkinson. The state in this case is represented by attorney Haley Simmons. She's sitting first chair. And sitting second chair is attorney Andrew Hubel. And we also have attorney Shane Hilton, who is also with the district attorney's office. He is also participating in the trial as well. You have, and our court reporter in this case is Miss Ada Christie. She's sitting to my left. Please speak up when you are asked questions, or if you have questions, because Miss Christie needs to listen to everything that's being said. She's typing everything that's being said. The bailiff in this case is Miss Brenda Mosby. I think you met her earlier. The defendant stands charged by information. Now, in a misdemeanor case, a person gets charged by information, unlike a district court case, they get charged by an indictment. Okay, so the defendant stands charged by information with the Class A misdemeanor offense of assault, bodily injury to a family member. The punishment range in this case, it is a Class A misdemeanor. And the possible punishment that a person can receive if convicted of a Class A misdemeanor is minimum 0 days to a maximum of 365 days in the county jail, or a fine that does not exceed $4,000, or a person can be given both such fine and confinement. The state and the defendant, through their attorneys, have the right to direct questions to each of you concerning your qualifications, backgrounds, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide this particular case. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up to the bench so that we may discuss the matter more privately. Is the state ready to proceed? Is the defense ready to proceed?
We are, Judge.
Okay. And Ms. Simmons and Mr. Wilkerson, is 30 minutes enough for an hour?
It should be fine.
Yes, Your Honor.
Okay, and I'll be keeping time. At this time, Ms. Simmons, the panel is yours.
Thank you. Good afternoon, everybody. How are you doing? We're so happy to be here today. Did anybody else raise their hand? Okay, two. That's awesome. Y'all laughed the last time no one raised their hands. So that's all I got for you. Before I get started, I kind of want to tell you all ahead of time, my voice is a little raspy. I lost it over the weekend. My biggest fear would be to lose my voice hearing track of that. Here we are. So I'm gonna speak as loud and as best as I can for you. This is lovely. Okay. So in return, I ask that if y'all are asked a question or spoken to, if I do intimidate to every single one of you, make sure y'all speak up. We do have a conflict reporter here. She's taking record and note of everything that is being said. Okay. Okay. Everybody do that for me? Okay. Who here has jury experience? A lot raising their hand, a lot wouldn't have to be here. I wonder if that has anything to do with it. Go ahead and raise your hand. I'm gonna go down the line here. Did you remember one? Did y'all reach a verdict in that case? Juror number 2?
Yes.
Keep y'all's hands raised when we know. Y'all raise your hand in that case. Juror number 4? Yes. Juror number 5? Juror number 6? Juror number 7?
Yes.
Juror number 10, were y'all able to reach a verdict in your case?
Yes.
Okay. Juror number 12, were y'all able to reach a verdict? Juror number 14? Yes. Get to the back row, I can't see over everybody. Juror number 15, were you able to?
Yes.
Juror number 16, were y'all able to reach a verdict? Juror number 18? No. No, okay. Juror number 19, were y'all able to reach a verdict? Okay. Just wanna know, for those that didn't raise their hand that were excited to be here, was it because y'all were on a jury in the past? Y'all just really didn't wanna be here, it's Monday, other things you can do. Okay. So as Judge said, we're here today on an assault. A person commits an offense if the person intentionally, knowingly, or recklessly causes bodily injury to a family member, household member, or dating partner. You might not know what every single word means up there. I'm gonna kind of dig into the definition a little bit, but before we get started, has anyone here ever been a victim of an assault? Is that Hanson? Okay, I saw you kind of tilt your head a little bit. Nobody here has ever been the victim of an assault?
My brother hit me, does that count?
I don't think it does.
I didn't file charges.
But you've been a victim of an assault. Okay, right, if we have siblings, we kind of know what it feels like, right? Okay. Did y'all ever go through the court proceedings, legal proceedings, kind of just tough it out, shook hands, went on about your day?
Well, we just went off. We didn't shake hands.
Okay. Does anybody know anybody that's been a victim of assault? Can I get a raise of hands there? Okay. Were they close to y'all when y'all, juror number 12?
Well, that's my husband in his line of duty, it happens.
Okay, you say in his line of duty, is he
He's a police officer.
a police officer here locally?
Yes.
Okay, what agency do you don't mind me asking? Lamar PD, okay, who else raised their hand? Juror number 5, Hanson, correct? Were they close to you? Daughter, okay, has that affected her long term? Is it affecting your family?
Passed it, but,
Okay. Let me ask you this, is it something that hits home to you when spoken of in terms of an assault? Would it cause you to be, or would you be able to be fair and impartial in this jury? Hard not to think about, but if you were picked as a juror in this case, would you be able to set that to the side and just focus on this case? Raise a hand again to those that know somebody, juror number 7, who was it in relation to?
It was a fellow who owned the restaurant.
It was who, I'm sorry,
A fellow who owned the restaurant.
the restaurant?
Was not close to him, just dated his place, knew him from that. Never saw him outside of that. But yeah, we deal with him, real big.
You saw how it affected him?
Oh, yeah,
It changed his maybe demeanor?
good, broke his head. That was a pretty big problem for him.
So people get attacked, it sticks with them, they have to live with that. You'd say there's everlasting effects, it affects family, friends,
Definitely.
husband, spouses, things like that. They're also on the back end. Juror number 15, is it
Yes.
Mr. Block?
Okay.
Blockade, I tried. I'll get it right next time, though. Mr. Blockade, who in relation to you?
I had a granddaughter that was assaulted.
Granddaughter?
Yeah.
Okay. Did it affect you as well, throughout the whole family? Did it cause
Sure.
people?
Yeah,
Is it something she still deals with today?
yeah, I just found out about it. There was never any charges filed, which
How does
actually
that
should
issue?
have, but
So you do think that charges should have been brought forward? You think it should have been handled by the courts?
yeah.
Anybody else on that back row? Did I miss anybody? Okay. Juror number 4, did you raise your hand?
Yes.
I missed you, I'm sorry.
It's okay.
And it's Castillo?
Yes,
Okay. Who in relation to you?
that was a good friend of
A
mine.
good friend of yours? Are y'all still good friends?
We are.
And how did it affect her, do you know?
I mean, she's okay now. It's been years, maybe 3+ years since it happened, and she's moved on.
But everybody that says they've known somebody that's been affected, you've seen the effects, right? You see changes in behavior, demeanor, things like that. Let's move a little bit on to the assault. And this is exactly what we just talked about in terms of the definition. This is my burden. This is what I must prove to you. And that is defendant on or about a certain date in Jefferson County, Texas, did intentionally, knowingly, or recklessly cause bodily injury to a family member, household member, dating partner. And I know that's a lot of verbiage right there. I want to pay attention to intentionally, knowingly, or recklessly right here. You see that or those are the state of mind elements here. I don't have to prove all of them. Or if you were selected in a jury in this case, when you go back to deliberation, y'all don't have to agree on the same one. So juror number one, if you were to find that the defendant intentionally caused bodily injury, but juror number two, you were to find that they knowingly caused bodily injury, that's not going to be a problem for purposes of this trial. As long as you go through and you make sure the state has met their burden on every single element. Anybody have problems with that? We're all good here? Okay, so let's get to bodily injury. Means physical pain, illness, or any impairment of physical conditions. Anybody know exactly what that means? No? Okay. Does this mean serious bodily injury? Juror number three. For purposes of bodily injury, do you think I have to show serious bodily injury?
Not necessarily. I mean, it wouldn't have to be hospitalized or anything to be injured.
And what about juror number four? Are the injuries required to be physical? What do you think? No. No. But juror number five, that's Hanson, correct? Must they feel pain? They do. So for purposes of bodily injury, when I'm proving up my burden, I have to show that there was some type of pain. Now, juror number four, you came in and you said that I don't have to show you physical injuries. And that's correct. I mean, sometimes it might be hard to see who here has long hair. Juror number eight. If I came up to you and I grabbed your hair, you think that's gonna cause you some pain? You think anybody's gonna see that injury around you? No. But you still felt that pain, right? Were you still assaulted? Does everybody understand what we mean by that pain element? When it comes to bodily injury? Does anybody have any questions on that? Family member, I know this is tiny, I'm gonna read it out to you. A lot of it's pretty self-explanatory, but I still wanna go down the line just in case. So for purpose of this case, a family member is anyone related within third degree of consanguinity or affinity, including former spouses. When we go to household member, it's the unit composed of persons living together in the same dwelling without regard to whether they are related. And then that last one, dating relationship. Relationship between individuals who have or have had a continuing relationship of romantic or some type of intimate nature. Does everybody know what those three things are? Let's take on someone new. I told you I'm gonna give everybody. So juror number six, you're up. Mr. Worsig?
Yeah.
What kind of things would you want to see in a assault family violence trial?
I mean, you mean like proof or?
Like evidence, what kind of evidence would you want to see?
Repeat it.
Do you want me to just come up here and be like, hey, he did it? You want to see something, right?
I want to see proof. Yeah, I want to see.
Okay. What kind of proof though?
Injury.
Injury, okay. Everybody else agree with that? Want to see some type of injury? Want to hear some type of element that there has been pain? Okay. Let's see, juror number 7. Stabbing. Anything you'd like to see?
Well, I would think you'd expect to see a photograph of the injury. You expect to see a statement from the police, or for a doctor, or an ambulance driver. That sort of thing, you know, you wouldn't just want gossip, you want to see proof.
So you want somebody to come up here and tell you what happened, and you want to see pictures of that, right?
That's what I would expect.
You want to see body camera footage from the officer?
Yeah.
Everybody else want to see that?
Available.
If it's available. What about witness testimony? Does that count as evidence? If I have a witness coming up to testify, is that evidence for purposes of trial?
I would expect.
Yes,
Absolutely.
first hand.
Good, absolutely. So everybody wants to see those things, right? We want to see photos, we want to see videos if we have it, we want to see injuries, we want to hear someone testify in terms of what happened to them. Correct?
Yeah.
Witness testimony like we talked about. Kind of tiny, I'm gonna read it out. I'm gonna have everybody get a number together for me. And I'm gonna go down the line and grab it. So if supported by the evidence, how comfortable would you feel finding someone guilty of assault without visible injuries? I'm gonna go down. We have 1 as in very comfortable. 2 as in uncomfortable. 3, somewhat uncomfortable. I know this is a lot. 4, somewhat comfortable. 5, comfortable. I know. 6, comfortable. Everybody feels differently about these things. So everybody pick a number. I'm gonna go down. Juror number 1. Where are you at on that scale? 5. Juror number 2.
4.
4. Juror number 3.
Or
There's no right or wrong answer, guys, I promise. Juror number 4. 4. 4. 5. 6.
4.
7.
I'm a 4.
8. 9. 10.
4.
12. 13. 14. 4. 15.
5.
5. 16. 4. We have 18. 6. 19. 4. And 20. 4. Okay. Like I said, guys, there's no right or wrong answer. I'm not trying to trick you during jury selection. We're just trying to find the best for our jury, okay? So now that we've gone through that, let's keep going. A little more to the tricky questions, okay? Juror number 8. What do you expect the victim of an assault to look like? You think they all look the same? No. Can anybody raise their hand and tell me without a doubt that if the victim came up here and testified, they look the same as everybody else? Okay. Juror number 9, how should they behave?
Great question.
Right?
I don't know, everybody handles things differently. Is there a right or wrong answer to that?
Do y'all think there's a right way to behave when you've been the victim of an assault? Y'all think there's a wrong way?
No.
Do y'all think everybody behaves differently?
Yes.
Does everyone react differently?
Yes.
Good. Brings me to my last question. I think we're all on the same page right here. Are all victims meek, timid, and shy?
No.
Do we expect the juror to come up here and just be scared to talk entirely?
No.
It's possible they could, right?
Yes.
But that's the thing. If you're selected as a juror in this case, you get the ability to sit in that jury box back here. You get to listen to witness testimony, and you get to be the judge of that. You get to look at their demeanor, their behavior. You get to see the videos, the photos. You get to see those things, and it is your job as a juror to see how you assess their credibility. But we all agree, for a show of hands, we all agree that they don't act the same, correct? One witness. This is a fun one to talk about. Texas law does not actually require me to bring forward a specific number of witnesses to a crime. What it requires for me to do is prove my burden beyond a reasonable doubt. Can anyone tell me why I don't have to have a certain amount of witnesses? Might not be people around. Maybe someone didn't see it.
Their stories may vary.
That's true. Do you think a conflict in testimony is something that you would assess as a juror, or is it something that would negotiate my burden in time? Or let me ask that, let me rephrase that. If there's a conflict in testimony, are you going to assess the credibility of that? Will you weigh that?
No, I mean, it's your burden to prove.
Right, the burden's on me entirely. The defense has no burden whatsoever. But y'all get to weigh the witness testimony, and if y'all see conflict in testimony, y'all will be the sole judge of that, okay? But let me ask you this, who did I stop? I stopped at you. You're number 10, you're up, Mr. Gordon. Who decided where the crime occurs? The witness does? Does the witness say, hey, this is gonna happen right here, right now?
Oh,
Who would be the person that did that?
person who committed the crime.
So the defendant, right?
Yeah.
Juror number 12. Who decides when the crime occurs? So you're saying where the crime occurs is the defendant, right? When is the defendant, right? Juror number 13, who decides how many people the crime occurs in front of?
The actor, the defendant? Do you think someone's gonna strike somebody or hurt somebody or attack somebody with an audience to see? I mean, they kill,
Depends on how angry they are.
right?
Lot of bar fight.
That, there you go. Do you think it's normal though for somebody to just in public, just go attack somebody?
Not with a bunch of witnesses.
It's ultimately your choice though, right? Yeah, not with a bunch of witnesses. If you saw me in defense counsel over here, I've got all of them, right? You'll see everything happen. But for purposes of this trial, when you're thinking about who's deciding when it occurs, where it occurs, how many people sees it, it's the defendant making that decision, right? Very determining when they're making that decision. Could that be an explanation as to why there might be one witness? So if I had one witness brought forward that was able to testify to each and every single element, would y'all be able to find guilty if the state met their burden with just one alone? Would anybody have trouble with the one witness rule?
I mean, if it's a police officer,
What if it's somebody else? What if it's not a police officer?
you have to figure out if that person's,
Right, who's
if they're
doing,
credible or not.
who's checking for credibility? Is the juror looking to see their body language, their demeanor? That's y'all, right? Are y'all
Yeah.
assessing their credibility there? What if I told you, you brought a police officer and a witness, just a lay witness or an eyewitness, they'll start with the same credibility. A police officer could be given no greater weight in terms of credibility when it comes to emergency testimony. Well, we might all be in trouble there, right? So nobody has problems with the one witness rule, right? Things I am not required to prove. I showed you all the elements that I have to meet beyond a reasonable doubt or have to prove. I don't have to show you motive, how many times the victim was struck, the size of the victim, the size of the defendant. I don't have to tell you who was present for the assault. For purposes of this trial and me meeting my burden, I just have to prove up every single element beyond a reasonable doubt. Does everybody understand those things? Of course, we might want to hear these things, right? We want to hear why it happened, where it happened, the reasoning behind it. But it's not required for purposes of my burden. Does everybody understand? It's reasonable doubt. This is always fun. Texas law requires a state prove its case beyond a reasonable doubt. Does anybody think I have a definition for that? Juror number. What number? Bless you. 18. Juror number 18. Help me with that last name. How do I pronounce that? McDonough. You said yes. You think I have to give a definition of beyond? I don't think you have to, but I think there is a definition. There is not. Excuse me. Sorry. No, that's okay. It's okay. I cannot give you a definition of this term. What I can tell you is not beyond all doubt. If it was beyond all doubt, where do y'all think that would be? No, you wouldn't be here. I would have subpoenaed you as a witness and you'd be testifying. Because that means you were probably there, right? If you had no doubt as to what happened, we probably saw it, huh? Right. Not beyond a shadow of doubt, not beyond an unreasonable doubt. There's a lot of TV slang that gets thrown around, that gets confusing here. Beyond a reasonable doubt. The best way to explain it, I'm so sorry, Mr. Donovan. You will know it when you see it. That's all I can give you. And that brings me to this fancy slide, common sense. When you have trial, you're gonna see the evidence, the testimony, all these things. It is your job as a juror to piece them together. With your common sense, you will be able to determine if the state has met their burden beyond a reasonable doubt on every single element. Does everybody understand that? What do you see? Those are difficult. Can anybody tell what those shapes are made out of? Or what they are? Juror number 7, raise your hand.
On the left, it looks like valves, like engine. In the middle, that looks like.
Well, you are specific. They're puzzles, right?
In the middle, it looks like a dough, and the top right obviously looks like a puzzle piece. But I don't know what puzzle piece it is.
You do see puzzle pieces, right? There's something, right?
All right.
Can anybody make out that puzzle like me? Anybody? Me neither. Can anybody see the puzzle now? Are we missing pieces in this puzzle? Can anybody see what the puzzle's actually combined to make? What does it depict? Juror number 9. A gun. A gun? But I'm missing pieces, right? What are you positive it's a gun? Yes. So it's kind of like trial here, guys. You may not have every single piece to the puzzle, but when you piece it together, you're gonna be able to see if I've met my burden. Same thing here applies. That's the way to explain. Does everybody understand this one as well? No vowels. It's just a gun.
I was showing where the gun was.
Oh, okay. I'm sorry. Presumption of innocence. Does anybody know what presumption of innocence is? Number 2.
He's innocent to prove guilty.
So as he sits right here, is he guilty? Everybody agrees that, right? Who has the burden to prove that he is? Does he have one? Absolutely not. That burden is on me and me alone. Good. So everybody has a presumption of innocence. Just because he's here before us today on trial does not mean he is guilty. It is my job to prove that. Defendant, like we talked about, burden, absolutely nothing. You are not to lay any type of burden on the defendant whatsoever. The burden is entirely mine. Defendant has subpoena power. He has the right to discovery. He has the right to trial. He has the right not to testify. If he were not to testify, would anybody hold that against him? Good. And he has the right to defenses. Anybody have any questions here? Okay. All right. We kind of talked about this a little early on. Raise your hand if you know anyone that's been a victim, and I know several did. But let me ask each and every one of you this. Does anybody think this is a problem in our community? Show of hands. Family violence. Pretty much everybody shaking their head, nodding their head, raising their hand. What do y'all think the state should do about it? Do y'all think this is something that should be handled in the courts? Juror number 6, you said,
I mean,
what is that?
counseling,
Counseling? So you think there's alternative routes? Okay. Does anybody else think that way? If we know somebody that may have been assaulted or injured or has felt pain by another member? Does anybody think that the state shouldn't step in? Does everybody outside of that agree that this is something that should absolutely be handled in the courts? Show of hands, help me out here. Anybody that feels that it does not or should not be handled in the courts? A lot of
Well,
contentious
you can,
cases.
I mean, if you don't settle it in court, what,
What comes out of it, right?
or, yeah, I mean, yeah, there's no.
It's in the penal code, so it's gotta be handled in court.
So everybody
Also,
agrees that there's a crime that's committed, the court should step in and take care of something, right? Show of hands, reporting it like that. Does everybody agree with that? Okay. All right. Let me ask you this, your number 5. Is it your number 5? Yep, Mr. Hanson. You said it was your daughter, correct? Do you mind if I talk to you a little bit about it? Yes.
If necessary.
If necessary. Well, let me ask you this. When you say your daughter was assaulted, did she leave right away?
It's not part of discussing.
Is there anybody else? Juror number 15? Would you
No.
feel comfortable talking about it?
I'll tell you, to tell you the truth, I just found out
You just
about it.
found out?
She was in College Station and her boyfriend assaulted her. And she had pictures of the bruises in the face
Everything that
and
happened?
everything. And they didn't tell me till 2 days ago.
Do you know if she left right away? Does anybody think that somebody that's been assaulted by someone that they love or someone that they care about, that they're always gonna leave right away? Mostly they don't. Do you think they report it right away?
no,
Do they ever go back? Yes.
Yeah.
Is there always a question of how many times did it happen? Now, juror number 14, do you think they always call police?
No.
Can anyone tell me a reason why they might not call police?
Scared.
Fear. Everybody feels that sometimes things don't always come out at the immediately due to fear, retaliation, other things such as that. Does everybody understand that?
Could just be embarrassed.
Embarrassed? Yeah, absolutely.
Think they deserve it. I don't agree, but.
All right. Some might feel guilty.
Guilty.
Maybe kids, family, they don't want that type of.
To go to jail or.
Right. So everybody understands that not only do we see differences in terms of how people respond, in terms of their body language, their demeanor, when they call the police, things like that, but there might be reasons as to why they don't do it. So here's your duty, if you're selected as a juror in this case. You'll decide the facts, you'll apply the facts to the law, and then you'll follow the law. So I've kind of laid out the law before you here. Is there anyone here that feels that they cannot follow the law? Is there anybody that would struggle to sit in judgment of another, maybe religious or other reasons? Could everybody be a fair and impartial juror in this case? Is there anybody that feels like they would not be a fair and impartial? I don't really get to speak to y'all much during this trial. This is my kind of last opportunity. Does anyone have any questions for me? All right. Well, I'm finished up here today. Thank you all so much for listening to me. I will be presenting this case to y'all.
Mr. Wilkerson, you may proceed.
Good afternoon, ladies and gentlemen. My name is Marcus Wilkerson, as you heard earlier, and I have the privilege to represent Mr. Daenerre High in this matter. Obviously, we're in the section or the phase of the trial where we get to ask you some questions and determine if perhaps it really should be called juror unselection because that's what happens, right? If we determine that you may not be the best person to potentially sit on a jury in this case, then you would be stricken. And those of you who aren't stricken are actually the ones who end up being here. So that said, it's also the case that quite often jurors who don't speak up when they're asked questions, those are the ones we know the least about, right? And so when we're sitting here thinking about, okay, who do we want on this jury? Who do we not want on this jury? If you haven't engaged with us and we don't know much about you, then you might be more likely to end up on the jury. And maybe that's a good thing for you. What I would caution you to, though, is these questions that you're being asked both by the state's attorney and by myself are very important with regard to deciding this case ultimately. And y'all, let me apologize too. I'm getting over either the flu or COVID. Anyway, I forgot my inhaler at the house, so if I get a little winded while I'm talking to y'all, that's fine. So I want to start off by the favorite topic, right? Burden of proof. Mr. Davis, juror number 2, you were asked about the presumption of innocence, and I believe you said that the defendant is presumed innocent until he is convicted. Is that correct?
No, until he's proven guilty.
Until he's proven guilty. Okay. So if we say that he's presumed innocent until he's proven guilty, doesn't that presuppose a conviction? So what it really is, right, is the defendant is presumed innocent unless the state proves their burden beyond a reasonable doubt that the defendant committed an act. Right? These little language cues, they can really affect how you think about these things. Language has power. And so I would encourage you to keep an open mind, especially when you're hearing, well, the defendant decides when an attack happens, or the defendant decides how many people are present. Remember, if you end up on this jury, that those things, if the state makes those allegations in court, then the state's gonna have to prove those in court. So don't let it sit in your mind that just because Ms. Simmons asks you questions about certain matters, that they're necessarily part of this case. I want to caution you about that as well, right? So, a number of y'all have served on prior criminal juries. A number of you have served previously on civil juries. And a couple of you have actually been party to a civil case. Mr. Dickens, I believe you indicated, and correct me if I'm wrong, I believe you indicated that you had actually been accused of an offense at one point. Was that? Do you recall completing your juror questionnaire?
Yeah.
Okay, on your juror questionnaire, where it asks about criminal trial experience, you indicate, beside accused, it says true. Was that meant to be reflective of having previously served on a criminal jury? Or were you ever investigated, accused of having, committed an offense?
No, I got a DWI in 2003.
Okay, so, in 2003, were you able to take a deferred education on that, or?
No, I ended up pleading guilty and did my probation.
That,
I mean, in a sense.
good, glad to hear that, and, thank you for sharing that with us. I don't think anyone else in here, has ever been accused of crime or an offense. If I'm wrong, could you please raise your hand? Has anyone else ever been accused of an offense? Yes, sir, juror number 2.
Yeah, when I was in college,
Okay,
it's misdemeanor.
misdemeanor. How was that ultimately resolved?
I did deferred education, did some, cleanup on the roadways.
A little bit of community service, a little bit of
Community
probation. Hey, you know what? I did it in undergrad myself, so I'm not knocking it, right? We all have a past and it all makes us who we are here today, right? And so ultimately the question is, are you happy with who you are today? Because if you are, then your past, it doesn't define you in a negative light. So, also, a number of you have kids. Most of your kids are grown at this point, but when we talk about the standard of proof beyond a reasonable doubt, I want you to understand what that standard of proof truly means. So, those of you who either have young children now or who had children at one point in time, anybody want to share with me what they think the standard of evidence is to terminate your parental rights with your child? It's okay, you probably get it wrong. I'm asking because I want y'all to understand this level of. All right, the evidentiary standard. Excuse me, my mouth also gets very dry. In order to terminate a parent and child's relationship in the state of Texas is clear and convincing evidence, which is a rung down from beyond a reasonable doubt. So beyond a reasonable doubt absolutely does not mean beyond all shadow of a doubt. But it is not something that you can throw up and say, hey, you got these pieces of a puzzle, put them together on your own. Let me ask you a question. Say I show you a picture of a green and yellow tractor. Now, when I show you that picture, what is the puzzle piece or pieces that are missing, and maybe it's just one piece, is a piece that says John Deere. With that piece missing, can you say beyond a reasonable doubt that that tractor is a John Deere tractor? Anybody? You can't, right?
Just because it's your brain doesn't mean it's
And so, and there's the rub, right? It really depends when you're talking about putting pieces of a puzzle together. It really depends what pieces you are missing and what you're being asked to put together. So, if parent-child relationships are terminated by clear and convincing evidence, I want, when you're thinking about beyond a reasonable doubt, I want you to think about that. Think about if somebody made an allegation against you, right? Maybe it was a school, maybe it was a friend's, or a friend, a mother or father, of a friend of the child, because, let's say your kid's arm was broken. And really, your kid fell out of a tree. But your kid has decided to say that you broke his arm because he's angry and upset about it. Right? So if the state, if you then have your kid removed from you for abuse, and if you do not adequately work your services, right, with a child protective agency, for instance, or deal with an allegation within the criminal domain, the state can then come along and say, well, actually, we believe based on your non-participation or your refusal to go to anger management, while this matter has been addressed, we don't think you should get your kid back. And so all we have to show is by clear and convincing evidence that you abused this child and that it's in the best interest of the child, therefore, to not be with you. So think about that in terms of how much you would want the state to prove in order to take your kid. Do people make false allegations?
Yes.
Anybody here just never heard of somebody alleging something to have occurred? No? All right, good. What I'd like to do, I want to try and get a sense of what y'all believe or what y'all feel with regard to our criminal justice system today. And so, first, I'm going to go down the front row here, and I'm going to ask you, do you believe that sentencing upon conviction is for punishment or rehabilitation? If you're given that choice, which do you think? Let's not say what we want, let's say what we want it to be, what we would hope for, right? Not what you end up with. But if you convict someone and you sentence them, what do you hope for out of that sentence? Juror number one, punishment or rehabilitation?
I think by punishment, the person should be rehabilitated.
And so you think that, if I hear what you're saying correctly, you're saying that you believe that in the punishment, or that the punishment should sufficiently deter any future actions that might be taken of the same nature?
Hopefully.
Hopefully. Mr. I'm sorry, I messed up how I wrote your last name, Mr. Davis. Punishment or rehab?
Punishment.
Punishment. Mr. Dickens, punishment or rehab? Punishment. Ms. Castillo, punishment or rehab? Mr. Hansel, punishment or rehab?
I believe it's both. That's an acceptable answer, depending on the individual circumstances. Punishment should lead to the rehabilitation.
Or it could depend on the severity of the.
Severity of the offense, right? So I stopped, let's see, Mr. Worsig?
Yeah. I mean, rehab, but sometimes you need punishment to get you there.
Mr. Daddy? Mr. Kelly?
Yeah.
Rehab? Ms. Ross?
It depends on the person and what they're being convicted of, but I'd like to go rehab.
All right. And then, Mr. Gordon?
I'd say both depending on the crime.
All right. Ms. Hollier?
Yes, definitely getting on circumstances, but also go rehab.
Ms. Brown? Ms. Wolford? Oh, I mean, that's kind of not fair. I'm not giving everybody the opportunity to say both, but I understand why some of you are splitting the difference. I do. I understand what you're trying to say. Mr. Bass, Bate, correct?
Okay.
Yeah.
Bate,
Punishment.
punishment?
Yeah.
Ms. Bell?
Punishment, no, it's up to the person to me, figure out whether they wanna rehab or do it again.
All right. Number 18, Ms. McDonough?
Make that
McDonough?
punishment.
Punishment? Juror number 19? And juror number 20? Right, rehab. So over the past 8 to 10 years, there have been a lot of issues arise with regard to criminal justice reform. So just kind of in brief, what I'm going to ask each of you now, I'm going to go down the row and ask you if your attitude toward law enforcement has improved or gotten worse over the course of the last 8 to 10 years. Juror number 1.
Give my attitude towards the law enforcement.
Yes, sir. What you think of law enforcement agencies, has that opinion improved or has it gotten worse?
It hasn't changed at all.
No change at all?
No.
Juror number 2.
Yeah, no change.
Juror number 3.
Locally, state, I would say good, got better. Federally, it's gotten a lot worse.
Juror number 4.
Worse.
Juror number 5.
Change.
Juror number 6.
I would say unchanged.
Juror number 7.
Unchanged.
Juror number 8. This is the first time I've ever had this many unchanged, y'all. So juror number 9.
Unchanged.
Juror number 10.
Worse.
Juror number 12.
It's a hard question, because based on my experience, and I was in it for 19 years, and then my husband's still in it, I have 2 nephews, and I know circumstances and how hard it is for them and what they have to deal with. So in one way, it's worse because this personally, what they deal with is bad. But as far as, you know, it's totally support the police.
Yes, ma'am.
100%. So that's, yeah.
You work for an attorney's office, correct?
I did before I retired, but before that, I was with sheriff's department for almost 20 years.
Okay, so you're a former law enforcement officer yourself? Okay, thank you for sharing that. Juror number 13. Over the past 8 to 10 years, has your view of law enforcement, has it improved or gotten worse?
I'd like to say it's improved.
Juror number 14, unchanged. Juror number 15,
Unchanged.
unchanged. Juror number 16,
Unchanged.
juror number 18,
Unchanged.
juror number 19, juror number 20. Right. So, with regard to credibility of a witness, what are some reasons that someone might accuse someone of assault if that person did not commit the assault? Mr. Davis?
Just doesn't like the person.
So out of, antipathy, for instance,
Yeah, there's a grudge, and there's past experience.
right? Juror number 5, would you like to expound on that? What are some reasons you think someone might make allegations that someone assaulted them if the assault didn't occur? Retaliation? Anybody else got anything different than retaliation or because just out of a general dislike for someone?
Being denied something they wanted.
Being denied something, and your turn number 10, correct?
They're trying to get out of trouble, you know, and they put it on somebody else, so.
So
Like that.
maybe to create an alibi for themselves or something of that nature.
Or to gain something. For themselves. By lying.
Child may be involved. For child.
Revenge.
Revenge. And your number 16, correct? I'm sorry, and it was number 6, you said child involved, correct? Sorry, I'll have to make sure that our court reporter knows at least which number we're referring to, because in the record, right, you're not just labeled in there, either your name's recalled or your numbers show up in the record, right? So that's why I'm going down and making sure that I have a number or verify anybody who gave a particular answer. Let me ask you this. What do y'all believe is the best predictor of future behavior? Anybody?
Past behavior.
What's that?
Past.
Past behavior, right? So if somebody has behaved a certain way in the past, then you would presume that it's more likely they might behave that way in the future.
They could possibly, yeah.
Anybody disagree with that? That past behavior is a good predictor of future behavior?
Anybody can change.
I agree wholeheartedly with you. Anybody can change. And Mr. Worth is correct. But what are some things, well, let me ask this. Can males be victims of domestic violence?
Sure.
Absolutely.
And I think that was everybody pretty much in unison. Is there anybody who disagrees with that idea that males, and says, nah, males can't be victims of domestic violence or,
I don't think that's a gender.
not a gender issue, right? It crosses, boundaries. So, what are some things that you might expect, someone to do to try and de-escalate a situation, Ms. Ross?
I'm sorry, can you restate the question?
What would you expect someone who was trying to de-escalate a volatile confrontation between themselves and somebody that they had a dating relationship with?
Situational. Trying to leave the situation or fighting back. Depends on the people involved.
And so, how many of you would say that it is less likely that someone who was attempting were making attempts to de-escalate a situation between them and a dating partner, that how likely is it that that person initiated a physical confrontation? Juror number 10?
Repeat it.
Yes, how likely do you believe it is for someone who is making attempts to de-escalate a volatile situation? Whether the attempts are the same that you might make or different, that person would then initiate a physical confrontation.
Anything's possible, but I would think if they're de-escalating it, then they maybe didn't cause it.
And so you're suggesting then, if I understand correctly, that someone who is going out of their way to try and keep a volatile situation from getting any worse, probably did not initiate a physical confrontation. Is there anybody who disagrees with that? Anybody who thinks, well, maybe somebody's just trying to create the specter of de-escalating a situation, and then really, they just really want to pound on the person? No one?
I'm confused with the whole story here.
What,
Is it down there, can you repeat that?
yeah,
Well,
And you
it's not
did.
likely they're just trying to de-escalate, because they're gonna try to make things contact.
Yeah.
Instead of it being de-escalating, they'll be bringing the tone down, saying stop,
Or just walk away?
or just walking away, or whatever. So,
and that's ultimately what I'm getting at, right? The person who is taking steps to de-escalate a situation, would you likely believe that they're the one who initiated a physical confrontation?
Ms. Wilkinson, you have 5 minutes, 5 more minutes.
Thank you, Your Honor. So, if, would any of you think, that whether or not, someone lies about what took place immediately following, an alleged incident, how many of you think, that might impact whether you believe that the person was a victim or not? I see a head shaking. You're number 3. Would you care to share what you're thinking about this?
Well, yeah, if they lied upon the initial contact with police for whatever reason or another, and then I guess recanted later or decided, they might have been scared at the time, but usually, emotions are high or whatever, but yeah, I would think once the story changes, it's always suspect when the story changes, flip-flops.
Right. And so if someone who is allegedly a victim of this domestic violence, if they are demonstrably misrepresenting things that took place, you might think, okay, well, maybe we're not getting an accurate story from this person. Anybody disagree with that?
Disagree.
Yes, sir.
If it goes under extreme duress, can absolutely say anything to get past the situation they're in the moment. It's dynamic. Every situation is different.
All right, so in what you're discussing, Mr.
3 minutes. You have 3 minutes left.
In what you're discussing, are you considering that person is in immediate flight from whoever might have assaulted them? Or you're saying that they might do whatever they have to get out of the situation? So are you thinking that, they're lying to police about what happened so that they can get away from someone who assaulted them? What is it that you're trying to say?
Saying that victims often immediately following an incident may give any range of answers.
Okay. Do you think that range of answers, as far as what is said after an incident, impacts their credibility?
Sometimes yes, sometimes no, depending on the circumstances.
And you wanted to, discuss the, assault issue outside of the presence of the rest of
2 minutes.
the panel, correct? Is there anyone else, besides your number 5? 1, 2, 3, 4, 5, yeah. Anybody else besides your number 5 that feels like they have something that we've asked about that they need to share or want to share, but don't feel like doing it in the presence of everyone else? We understand this can be, these types of issues can be very personal for someone. And then, obviously, y'all, so it was already discussed whether or not, a somebody who might have been victimized might try and return to the scene. Would,
Yeah, 1 minute. You need additional time.
I can wrap it up, girl. I'm gonna stop there, because I think I've talked to y'all about the majority of what I need to. I really appreciate y'all being here. I know the defendant does as well. Without y'all showing up, no matter what comes of all of this, without y'all showing up, there would not be an opportunity for this defendant to seek justice. Or for that matter, for the alleged victim to seek justice. And if you do end up on the jury, I want you to remember that it is an allegation and that the state has to prove it. We can't disprove it, right? The state's job is to prove it. So I look forward to presenting the case to those of you who end up on the jury. Thank you again.
Okay. Okay, ladies and gentlemen of the jury, we're gonna ask that you, step outside into the hallway. We may call some of you back in for some follow-up questions. So you can use either one of the 2 doors to go out into the hallway, and you'll remain in the hallway until we call you back in. Okay, would everyone please stand as a panel, leave the courtroom? Jefferson County Court at Law number 2 is back in session. The court is in session and calls number 23 CCCR 0390, case of style of the state of Texas versus Denier High. Mr. High is present in court with his attorney, Attorney William Wilkerson. The state is present with Assistant District Attorney, Attorney Haley Simmons, and who's sitting first chair, and sitting second chair is Attorney Andrew Hubel. And let's see, we also have Attorney Shane Hilton, who is also present and sitting third chair with the state. State, are you ready? Defense, are you ready?
Yes.
Okay. Ms. Mosby, would you please bring in the panel? Everyone, please stand as the panel come back into the courtroom. Okay, you may be seated. Let the record reflect that the court is back in session and calls number 23 CCCR 0390, case of style of the state of Texas versus Denier High. Let the record reflect that Mr. High is present and seated in the courtroom with his attorney, Marcus Wilkerson. That the record also reflect that the state is present with Assistant District Attorney Haley Simmons. Sitting first chair, sitting second chair is Assistant District Attorney Andrew Hubel, and we have sitting third chair, Attorney Shane Hilton. At this time, ladies and gentlemen of the panel, our court coordinator, Ms. Redmond, is going to call some names. Which, if your name is called, please go and have a seat in the jury box. There are some tags, name tags that are on the counter of the jury box. You can take one of the name tags because it identifies you as a juror in this case. Ms. Trina Redmond.
Alana Castillo,
Alana Castillo, would you please come forward?
James Dabney, it should have been Patel,
Yeah, why don't you give one of those tags, Mr. Dabney?
Oh, all right.
Just grab one.
Doesn't matter.
Yes, Ms. Patel, you can grab one of the tags and have a seat in the jury box.
Brianna Ross,
Ms. Ross, get a tag.
Jane Collier, Lisa Brown, Catherine Woodford.
At this time, members of the jury, I must administer to you the second of the two oaths that I previously mentioned. So I need each and every one of you to raise your right hand. And once I finish administering the oath, please say, "I do." Do each of you do solemnly swear or affirm that in the case of the state of Texas versus Denair High, you will a true verdict render according to the law and the evidence, so help you God? Okay, you may put your hands down. Members of the jury, I will give you some instructions and a general idea of what to expect in this case. Every case is composed of facts and the law as it applies to the particular case. The facts come from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and court decisions interpreting them and how they may apply to this case. You and I have equal authority in this case, but it is divided authority. You are the sole judges of the facts, and I'm the sole judge of the law. You are the sole judges of the credibility of witnesses and the weight to be given their testimony. You can believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney or witnesses, or objections to introduction of documents or objects. This means that in the objecting attorney's opinion, there's a legal reason why the testimony or document or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can't hear the discussion on the point of law. The reason for that, as I told you earlier, you are the sole judges of the facts you receive, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate the facts, therefore you can't be present or within hearing when I deliberate questions of law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather her equipment and take it with her, and the attorneys would have to gather their files, etc. The rulings I do make on questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defendant have rested their cases, the court will prepare and submit to you a written charge instructing you on the law in this case. You will then hear oral arguments from the attorneys. The attorneys have the right to make a summation of the evidence and to make reasonable deductions from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument. Until you retire to deliberate, do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of the courtroom anything about the facts of the case, nor attempt to any independent investigation on your own. Don't visit the scene involved in the facts of the case. Don't read any reports in the newspapers or watch TV reports about the case. Do not make up your mind about this case until all the evidence is in and you have been instructed on the law. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. The tags that you have, please wear those tags at all times. Those tags identify you as a juror in this case. You will be allowed to take those tags home with you. Ladies and gentlemen of the panel, those of you who were not selected, again, I would like to thank you for taking time out from your busy schedules to be here this afternoon. our criminal justice system cannot function without people like you. In our criminal justice system, we only have a limited number of people that can serve on the jury. But I can assure you, your presence was greatly needed, and you were serving a significant role in this case. Now, I know that when you came here this afternoon, you probably looked over the top of the door and you probably said, oh, this is County Court at Law number 2. I'm in the right place. This is Judge Holmes' court. No, this is not Judge Holmes' court. This is your court. This courtroom is for the citizens of Jefferson County. I'm only an humble servant that's serving the citizens of Jefferson County. Now, anytime that you're in the area of County Court at Law number 2, you can come back and have a seat in your courtroom in the area that you're sitting in. We call that the peanut gallery, but it does not mean you can bring peanuts in here and eat, because this is not the Texas Roadhouse. But you can come and have a seat in your courtroom and just see what goes on in Jefferson County, and I'm sure you will find it to be very interesting. Now, our bailiff have letters for you. She's going to give each and every one of you a letter. If you'd like to drop us a line, you can. And before she do that, I normally give everyone a handshake. Of course, we still have the norovirus, and we also have COVID still in our communities. But at this time, I will give everyone what I call an air handshake. Okay? All right. Now, I would like to thank each and every one of you for coming out this afternoon. If our trial is going to be starting back up tomorrow, if you would like to come back in the courtroom and watch it, you can. If you cannot do that, you can watch it on YouTube. This court is one of the courts that is on YouTube. So at this time, you're free to go, and each and every one of you have a blessed day. Okay. All right, you're welcome. And nice seeing you, Mr. Gordon. Y'all can be seated. Okay, ladies and gentlemen of the panel, now State, you're gonna present your evidence starting tomorrow, is that correct?
Yes, Your Honor.
Okay, so ladies and gentlemen of the panel, we're gonna ask that each and every one of you be back tomorrow at 1:30. Make sure that you have a seat in the hallway, and then when court is ready to start with the trial, the bailiff is going to come get you. In just a little idea of what's going to happen on tomorrow. The state is going to read the information, and then the defendant is going to enter a plea to that information. And then from there, we will have our opening statements, and then the state will put on its case in chief. Okay? So at this time, you are excused for the evening. Everyone, please stand as the jury exit the courtroom. We'll be in recess.
Thank you.
You are.
Okay, that's just long.